My Lord, I beg to mention item 12 from part 2.
Yes.
I'm the amicus for the appellant, my Lord. This is a conviction under POCSO Act. However, my Lord, there's no representation from the informant, my Lord. The informant was
Let's see.
arrested.
12. LCR is received. Amicus has been appointed. It says under section.
Section 10, my Lord.
So,
It seems AD card has returned, my Lord. I've checked the office note.
let's see. Yes, who is the additional PP?
Miss Mary is appearing.
See, this AD card most probably will be regarding the TCR. Yes, is there another file, correspondence file in this? This is under POCSO 10, isn't it? So we'll just appoint an amicus.
My Lord, yes.
Shortcut.
Yes.
Yeah, it appears that notice has been served and received. Mr. L. Tiang Lima, learned amicus for the amicus curiae for the appellant is present, along with Ms. Vanessiami, learned additional PP for the state respondents. It is seen that though notice has been duly received by the respondent number 2, none appeared for respondent number 2. In view of the above, this court find it fit to appoint Ms. Emily L. Chante, learned legal aid counsel, to represent respondent number 2. Full stop. The learned the registry, okay, is to inform the learned legal aid counsel and furnish a copy of the paper book to the legal aid counsel. List the matter. When do you want it? After 1 week or in the next week?
After 1 week, my Lord.
After 1 week.
Obliged.
Your Lordship, if I may seek indulgence on mentioning part 2, item number 6.
Yes.
Although all the concerns have been taken from the other parties, may this matter be listed out, like next week, if possible?
On the submission made on behalf of Mr. Is your name here?
Yes.
In the
Lilian
cost list?
Puikyangte.
Okay, then cancel that. Lilian Puikyangte, learned counsel for the appellant, has prayed for adjournment of the matter with the consent from the other side. In view of the above, list in the next week. Yes, you are there. The presence of Mr. Samuel Vanisha Dechante, learned counsel for
Sole respondent.
the sole respondent, as noted. Yes.
Motion, item 1.
May it please your Lordship. My Lord, this writ petition is filed due to the construction of road through the petitioner's lands in the petitioner's villages are Udal Thana, Nord Bania and Kamalanagar villages, Tungklai district. And under border area development program, your Lordship, construction of road was initiated and their lands wherein they have been paying revenue taxes were damaged without paying any compensation and without any acquisition, my lord. And other similar writ petitions, 3 writ petitions are still pending, and one had already been disposed of. There is WPC 62 of 2021. I have annexed in the copy as the annexes, my lord. And in that WPC 62 of 2021, direction was given by this Honorable Court for spot verification, and which was accordingly conducted and found to be correct, and thereafter they had already been paid. So the present writ petitioners are also similarly situated persons. So that is why we are approaching this Honorable Court, my lord.
Who is representing the respondents? Anyone today?
DC and state.
Anyway, we'll issue notice at this stage, then next date we can see whether a similar order can be passed, isn't it?
Yes, my lord.
Heard Mr. B. Laramega, learned counsel for the petitioners, who has filed the instant petition under Article 226 of the Constitution of India for the issuance of the appropriate writ to the respondents. Respondents full stop. In the case of the petitioners is that they are the residents of Udal Thana, Nol Bania and Kamna Nagar villages, Longklai district, Mizoram, and they are the rightful owners of their respective lands. The respondents, while undertaking the construction of the road linking Nagdora Sora village to Udal Thana and Gul Singh Bab Sora village, Longklai district, under the Border Area Development Program, within brackets, all in capital, BADP, close bracket, towards the end of the year 2020, had passed through and destroyed the petitioners' lands, full stop. The petitioners, however, were not paid any compensation on the acquisition of their land by the respondents, which is a clear violation of Article 300-A and also Article 21 of the Constitution of India. Full stop. The new para, okay. The learned counsel for the petitioners, okay, further submits that this that a coordinate, okay, the bench of this court, by its order dated 09/03/2023, passed in WPC number 62 of 2021, had passed an order to 5 petitioners who are similarly situated with the instant writ petitioners by directing that the respondents should conduct a spot verification and see whether the lands of the petitioners were encroached. Accordingly, on finding that the lands of the petitioners were encroached, the petitioners in the said writ petition number 62 of 2021 were paid the compensation due to them. Full stop. The learned counsel prayed that a similar order may be passed in the instant case. Full stop. Then you issue notice to the respondents. Mr. Samuel L. Sante, learned additional AG, accepts notice on behalf of
2 to 5, my lord.
the state respondents.
State respondents.
2 to 5, and Mrs. Zairam Sangpui, learned CGC, accepts notice on behalf of the respondents number 1. Requisite, no need to issue formal notice. requisite copies of the writ petition to be duly furnished to the learned counsels for the respondents. List the matter after 2 weeks. In the meantime, the learned counsels for the respondents will get instructions whether the instant writ petition is covered by the said writ petition number 62 of 2021 and whether it would be appropriate to pass a similar order as passed by the coordinate bench of this court. Yes, Mr. List the matter after 2 weeks.
My lord, I may take steps against respondents 6 and 7. Chakma Autonomous
Okay,
District Council.
meanwhile, learned counsel for the petitioner to take steps for service of notice upon respondents number 6 and 7 through registered post with AD within a period, within 3 days, returnable by 2 weeks. Then, in the end, it will be list after 2 weeks.
Highly obliged.
Admission, item 2.
Your Lordship, this revision under Article 227 of the Constitution of India is filed to challenge the impugned order passed by the learned trial court rejecting my application for amendment of the plaint. I, the petitioner, is the plaintiff in the learned trial court, my lord. All India Radio, Prasad Bharati, I filed one case against the respondent number 5 herein, who encroached the land of the All India Radio. And while the case was pending, the case is still pending, and during the pendency of the case, we found several documents regarding the acquisition of land, that particular land which we already acquired, which was already acquired and a word had already been paid. But those documents were missing at the time of filing of the plaint, the suit. So at the
They were in
belated
whose
stage,
possession?
it was in the possession of the All India Radio, the present petitioner.
It was
And-
with you all this time.
Yes.
Then how was it missing?
Though the records were missing for some time, and after we have found it, so we applied for amendment of the plaint. However, the particular point which needs to be considered is that if we read Order 6 Rule 17 CPC, liberal chance should be given to the plaintiff to amend the plaint, except after commencement of the trial. That is the issue which is very important in the present matter. The learned trial court rejected on 2 grounds. The first ground is that trial had already commenced, but not yet commenced. I'll explain it that later on. And another point is that no due diligence was given by the plaintiff, who is the petitioner herein. But due diligence question will come only after the commencement of trial. That is what the proviso says.
So
Still,
what is the stage in the
stage is-
trial court when you had applied for the amendment
yes, my
of the
lord. At the
plaint?
time of filing of application for amendment of the plaint, it was directed that examination in chief on affidavit should be filed by the plaintiff, but not yet filed. Supreme Court's ruling is very clear. When it is not yet filed, although
Not
direction
yet
was
filed,
there,
evidence not taken.
yes, not yet taken. So commencement of trial starts only when the evidence was submitted by way of affidavit. So, my lord, there is
Then we'll
the
have to see the records also of the TCR. Has it been called for?
I think not yet, your lords.
We have to see the order sheet. What is the stage? Because if that is going to be a point,
Yes, ma'am.
TCR called for, then we'll have to call for the TSCR and then we'll see.
My lord.
Your simple submission that this is it, this is the stage, but if the TCR is not available, then how can we
Yes,
verify?
my only, it is a simple
We'll have
issue
to look
only,
at the
yes.
order sheet.
Yes, and the learned counsel for the respondent, private respondent, he has raised the maintainability regarding 227. But that in that regard also I can argue, my lord. I have supporting citations as well.
Okay, so we will have this thing, we'll call for the TCR first.
My lord,
Let that be, because if that is going to be his ground, we'll have to see
my lord.
whether this thing, the examination in chief has been filed or not,
My lord.
and whether evidence has started or not. Yes. Heard Mr. Bilal Ramega. learned counsel for the petitioner, along with Mr. Laltiang Lima.
Si Laltiang Lima.
Si Laltiang Lima.
Si Laltiang.
Laltiang Lima. Learned counsel for private respondent number
5.
5, and Ms. Caroline K. Lalumoipu, learned government advocate for respondents number 1 to 4. 1 to 4. Okay, so the government has made the respondents number 1 to 4. Is it?
Yes.
So they are the ones who are the case. If they are the respondents number 1 to 4,
Yes.
then I think you'll have to make your submissions first concerning this, isn't it? Yeah. On hearing the submissions made by the learned counsels, this court find it necessary that the TCR should be available for perusal. In view of the above, TCR is to be called for list after 2 weeks.
Much obliged.
Item 3.
Chief, this is a petition for either release of my land or acquisition as per law. Actually, my lord, the Environment Forest Department, way back in 2018, my lord. has
No,
issued
so what
notification.
is the additional affidavit? What do you say in the additional affidavit? You have been paying time, isn't it?
Yes, it is stated, my lord, that it is well within the core area of acquisition. My lord. Paragraph number 6 of the additional affidavit. Your Lordship. The joint verification report records that the land claimed by the petitioner is situated within the core zone of Dampa Tiger Reserve, core critical tiger habitat required to presence. So it is well within the area. which
So
is-
why didn't you file your objection within the stipulated time?
That, my lord, as I have submitted in my petition, my lord, petition, I highlighted that portion of para 8 of my petition, my lord.
What did
Saying
you
that
say?
since I am the government servant, my lord, since I was at the relevant time posted in the interior places of Mizoram, here and there, my lord, so I was not in a position to know of all these proceedings that was taking place, my lord. So
And so what sort of a pass do you have within the
I
land?
have LSC, my lord,
LSC was issued to you.
was issued to me, my lord. Yes. Page number 12 of my petition, your lordship. Annex 1.
Wait, let's just see the additional affidavit first.
My lord.
See, you are claiming, so what sort of a compensation they can they give? It's relocation benefits.
Relocation, my lord, that was
But
not,
if you're not
No, my lord, I'm not
preside-
interested in that.
staying there, then
no, my lord. Since I'm not staying there, my claim herein is to either to release my land or to acquire it as per the relevant law of acquisition at the relevant time. Since that was done in 2018, it has to be 2013 Act of Acquisition, your lordship.
but the question is, can you be given landed property within areas which
That,
are
my lord,
declared?
was prior to acquisition, my lord. Prior to acquisition, I have this LSC way back in 2013, my lord. That LSC was issued to me way back in 2013. The acquisition takes place only in 18, my lord.
Okay, in 2018, your landed property was also declared, is it?
Yes, yes. That notification of declaration.
So have you addressed that issue? The government?
Yes, Your Lordship, if I
In
may,
para?
It is in the affidavit in opposition filed on March 2025, Your Lordship. In parent number 4, Your Lordship, may I read?
Yes.
That with regard to statement made in parent number 2 of the petition, I say that as per letter addressed to the Deputy Commissioner Mamit District by President of Village Council YMA, way back in 2010, Sermun villagers had offered to give their forest area to Dampa Tiger Reserve because the area is inhabited by animals, including those which are in danger of extinction, and for preservation of trees and bamboos. Furthermore, an application for relocation was made to the Chief Wildlife Warden on 31.
No, so his specific point, okay, maybe para 5.
That with regard to parent number 3 of the petition, it is humbly submitted that the state government expresses intent to expand the Dampa Tiger Reserve by incorporating the adjacent area of Sermon village encompassing an area of 54 square kilometers. This decision was motivated not only by ecological and faunal, geomorphological, natural or zoological significance of the region, but also in response to voluntary requests from the Sermon villagers. The request conveyed through the president of village councils, NGOs, and unit of political parties of Sermon village sought the inclusion of Sermon village areas in Dampa Tiger Reserve. Additionally, the villagers expressed
You are
a
reading from
willingness-
para what?
Parent number 5, Your Lordship.
That as stated above. Okay, you're this thing, wait, yes, para number 5.
So, yes, Your Lordship, I would like to submit that the villagers themselves were willing to vacate the said land, and this request was made from 2010 and 2011, and then the petitioner suddenly owns a 2013 LSC in that very core area. Now, the question is, even if he has owned the area from 2013 to 2017, and 2017 to 2023, there is a lot of lapse that is the reason why this petition has to be dismissed in the grounds of delay in legislature.
We'll have to look into the matter.
Yes,
okay?
Your Lordship.
Because now the scheme which they have, the state government within the reserve forest area is the reallocation scheme only.
Yes, Your Lordship, that is the
So,
central scheme.
and those who had, so we'll list it for hearing.
No, my lord,
This is one issue that has to be looked into.
if I may add one submission, Lord. Now, regarding now, I am not interested in the relocation fund scheme, ma'am. That is only meant for the residents of Serbun village who are not having any land pass. Who are not having any land pass issued by the revenue. I'm not one of them, ma'am. I'm not a resident of Serbun village also.
Your Lordship.
I am only having this landed property
So
as
we'll
an
have to
instructed
see, look
property,
into
ma'am.
your landed property which you're claiming this thing, no, because this is
There is-
slightly sensitive, so we'll have to look into it. We'll list it for hearing.
Yes, Your Lordship.
I think
It's not as simple as it appears, because here, Bounder, how did you have the land pass? Whether,
that, my lord,
Huh?
is not within, they have not even challenged that issue even till date, ma'am. They have not made any government notification or any progress regarding that also. And my lord, that also is not there in their affidavit, which was filed
that's
way
what I'm
back in
saying,
March.
have you addressed his
So-
main point? That's what I'm asking the state government, because this is within the reserved forest area.
I have
And,
earlier, my lord, it was not there. It was not within reserve forest. It was well outside reserve forest, my lord.
so what happened? So have you addressed
But Your
this
Lordship,
issue?
he was made aware, because if you look at, if till date, if one Googles 2017 Wanglaini, he is made aware, Your Lordship. So there is, you cannot, one
He's
cannot
made
claim.
aware of what?
He has to be, I mean, Your Lordship, when you are a government servant and there is a publication in the Wanglaini that there is going to be an extension of Dampa, one cannot claim that he was not aware that action has been taken within his landed property. So he should have made the objection back in 2017 or 18 itself.
When he did not, made or no, made an objection or not made an objection, the facts remains then that his LSC is there. But we have to see whether the state government is is to give compensation for an area where it is covered within the reserve forest area.
But Your Lordship, if
Is he the only person having an LLC within the said reserve forest area?
that will have to be looked into, Your Lordship, because
That's what I'm saying. Address that issue, which his main issue is. It is not that he's praying for the reallocation fund or whatever. Your affidavit seems to address only that he was not staying there, whatever. But his claim is that he happened to have an LSC
yes, Your Lordship.
within
However,
the reserve forest area.
Yes, Your
Okay,
Lordship.
so is it there? Have you addressed that issue in your counter affidavit?
no, Your Lordship, but then the section 20, the section 20 of the Wildlife Protection Act actually has a bar of accrual of rights. And the exception only is that if there's an inherited right in that particular area.
So he's saying he has an inheritable right.
But then he's only claimed that it is of 2013.
Huh? So when was it acquired?
It was acquired only in 2017 and 18, Your Lordship.
Then he has this thing, LSC within that area.
But then, Your Lordship, once the proceedings has been completed and that there was no challenge of the Wildlife Protection Act proceeding in this petition either.
That's what I'm saying. You address his issue, okay, because in your counter affidavit, you have only mentioned whether he is entitled to be compensation for reallocation. This is the scheme, that is the scheme, okay. The notification that was also issued. What is the notification?
It is there in my petition, page 18, my lord.
Your Lordship, the preliminary notification is on page number 29, Annex 5.
So this is
And then the
to
final
include
notification
the
is on page...
wildlife, isn't it?
Yes, Your Lordship, that is the prelim notification of 2017. And then there is the final notification on Annex 6, page number 21, 31, Your Lordship.
So acquisition can be this thing,
There is,
initiated under the Land Acquisition Act.
my lord, exactly.
But Your Lordship, now the
If I may
area
take-
The
falls
notification
under,
also says,
it falls under forest area now, Your Lordship, section 2
now
of the
it
Forest
falls,
Conservation Act.
but before that, you had given this LSC. What do we do with this LSC? Anyway, so we'll have a hearing on this, but are you getting my point?
Yes, Your Lordship.
Because previously you had prayed for time to find out whether the area is within the forest area.
Yes, Your Lordship.
Now that you find that it is within the forest area, let's see what is this thing stand.
My lord.
Heard Mr. Sizoram Chana, learned counsel for the petitioner, along with Ms. Lalnundul, learned government advocate for the state respondents, who submits that they have filed their additional affidavit, and copy be duly furnished to the learned counsel for the petitioner. In view of the above, it is seen that pleadings are complete. On hearing both the submissions made by the learned counsels, this court find it fit to admit the writ petition, list the matter for hearing. When you want it? After 2 weeks
My lord.
or in the next week? After 2 weeks?
2 weeks, Your Lordship.
Yes.
Obliged.
Item 4.
Yes.
Your Lordship, I have drafted the affidavit. If I may be allowed to file it within this week or next week, Your Lordship.
Mr.
Lalsanki Moralte, on behalf of my senior, Mr. Akero.
Lalsanki Maralte appears on behalf of his senior, Mr. A.K. Ropum, learned counsel for the petitioner, while Ms. Lalnundhui learned government advocate, has prayed for 1 week's time to file their counter affidavit. In view of the above, list after 1 week.
Much obliged, Your Lordship.
Item 5.
Yes,
We're seeking some more time to file a rejoinder.
rejoinder.
Some documents were recently discovered, my lords.
Okay. Mr. Jordan Rogminthaga, learned counsel for the petitioners, is present and has prayed for further time to file his counter affidavit. No, to file his rejoinder affidavit to the counter affidavits filed by the respondents. The presence of Mr. L.H. Shima, learned senior counsel for respondent number 7 and 8, and Ms. Vani Siami, learned government advocate for the state respondents as noted. Okay. List after
My lords, your lordships will give me 3
2 weeks. Okay, 3 weeks.
Grateful.
Item 6.
Your Lordship, we need more time to file our rejoinder because one very important document is not with us. We are applying for this RTI, through RTI. So we are still waiting for it.
Mr. J. Malsomzwal Avansom, learned counsel for the petitioner, is present along with Ms.
Laltan Louis for respondent 1 and 2.
Laltan Louis, learned counsel for respondent number 2, and Ms. Zarim
1
Sampul,
and 2.
learned, pardon?
1 and 2.
1 and 2, okay, and Ms. Zarim Sampul, learned CGC for respondent number 3. The learned counsel for the petitioners has, for the petitioner, okay, has prayed for further time to file his rejoinder affidavit. In view of the above, list after 2 weeks. How long will you take? I'm asking because I want to know how long time you require. 2 weeks.
Yes, it's definitely.
Yes.
Item 7.
Good morning, my lord.
Yes.
My lord, matter was supposed to come in the motion. I believe it's been wrongly listed in the admission.
Oh,
My lord, will remember the last petitions we had filed on the 4th. One of the entries in that list, my lord, at page 129, annexure 7, my lord.
we listed in the motion stage. It's been wrongly listed. Let the registry do the needful first. Okay, it's not appropriate when it's listed for admission, when it's never been put up
My lord.
before. Okay, so
My lord.
it is seen that this matter has been wrongly listed for admission while it should be in the motion stage. Mr. N. Kera, the presence of Mr. N. Kera through VC, learned counsel for the petitioner is noted. Registry to do the needful list in the yes, in the next week.
My lord, there is slight urgency, my lord, because they are going for verification process.
Okay,
My
tomorrow
lord,
is DB,
recollect.
so we'll make it day after. Okay, list
My lord.
day after tomorrow's date.
My lord, highly obliged, my lord.
Item 8.
My lord, permitted to leave.
Yes.
Obliged.
May it please, Your Honor. Your Honor, this appeal had been filed before against the interim judgment order passed by the land civil judge. The main suit is a money suit. And in the state money suit, the defendant also had the counterclaim. However, the land trial court had dismissed both the main suit and the counterclaim. And this present appeal had been filed by the previous petitioner. May I please take Your Honor to page number 35. We present our grounds of appeal. Your Honor, may I start from,
Where's the order? Where's the impugned order? The operative part of the impugned order. Let's look at that.
Your Honor, page number 16.
So, no, page number 21. This is the order, isn't it? So page number 21 of your appeal, issue number 5, whether the plaintiff is liable to pay rupees so and so to the counterclaimant. So it was decided against you. You are the claimant or what? You are the
We are
plaintiff.
the plaintiff in the trial court, yes.
You were the plaintiff, the
Plaintiff.
claimant, and the court decided that you are not entitled.
No, Your Honor, at the present appeal, the appeal had not been filed against the judgment regarding the counterclaim,
Then
only regarding the main suit.
main suit. Where is the operative part?
Your Honor, issue number,
Page 90. Issue which issue?
Your Honor, the plaintiff, page number 16. Please,
16.
Your Honor, yeah. Here, whether the plaintiff has locus standi to file the instant suit. And the land trial court had decreed that there is no locus standi. And Your Honor, page number 17, whether the plaintiff has cause of action in his favor.
Okay, so no relief was given to you.
No relief was granted.
Okay, fine. We'll show notice. Heard, Mr. Your good name, please?
Samuel Naramruata.
Samuel Lalramrota, learned counsel for the appellant, who has filed the instant appeal under section 17 within brackets 2 within close bracket, then open bracket, small b, close bracket, of the Mizoram Civil Courts Act, 2005, read with section 96 of the Code of Civil Procedure, 1908, against the judgment and order dated 10/03/2025, passed by the learned civil judge, within brackets, senior division, close brackets, dash Roman 3, Izol, in money suit number 84 of 2022, wherein the learned counsel had dismissed the money suit on the grounds that the appellant had no locus standi to file the money suit against the respondents. Appeal is admitted. Issue notice to the respondents, to the sole respondent, okay, through registered post with AD within 3 days.
May it please, Your Honor, may we take steps to dusting?
Let's do it through this thing registered first. If it doesn't, this thing work out, then dusting. Okay. To registered post with AD, returnable by 3 weeks. List after 3 weeks.
Item 9.
Your Lordship,
Yes.
I'm appearing for respondent number 7 and 8. We have received the additional affidavit filed by the petitioner, and I'm praying for time to file written objection and counter affidavit in the main petition.
So there's an IA. In the IA, you want to file a written objection, is it?
Yes, my lord.
What is the IA about?
Regarding an application for injunction, my lord, under order 39.
Okay. Heard Ms. Valentina Laldimpui, learned counsel for the applicant, along with Mr.
LS Laramswana,
L.S. Lalamswana, learned counsel for
7 and 8.
respondent number
7 and 8.
7 and 8. So, the learned counsel for the private respondent number 7 and 8 has prayed for time to file their written objection. Written objection. Okay. What about?
No, my lord, we will not have written objection till.
Okay. Full stop, Ms. Vanisyami, learned government advocate for the state respondents, submits that they will not be filing their written objection in the instant IA.
Your Lordship, we'll also be filing counter affidavit in the main petition.
In view of the above, list after
3 weeks, Your Lordship.
2 weeks.
My lord, if I may, regarding the IA.
Yes.
This matter has been pursued, my lord, because there is a starting of the MPL season 12 coming up next week on the 21st of August. So if at least an ad interim injunction before the next returnable date.
Well, what is the matter about?
This is regarding the illegal suspension and penalization of the petitioners, my lord. Their fundamental constitutional rights has been violated by the respondents, my lord. If at least an ad interim is not given until the next returnable date, the purpose of filing the writ petition along with the IA will be defeated, my lord. So if I may be.
IA is for stay of what?
Stay of the operation of the Mizoram Premier League season 12, my lord.
Where is that?
It is at page number 12, my prayer, at point number 2.
Where are the impugned letters?
It is at annexure number, from annexure number 4, my lord, page number 16.
No, this is MFA matter.
My lord, yes.
So, no, we'll list the matter next week. In the meantime, you have to file your written objection positively by next week, isn't it?
My lord, if we may
Because
have.
again, a stay, no. So you're saying what is coming up?
The Mizoram Premier League season 12, my lord, coming up on 21st of August, next Thursday,
21st of August.
my lord.
So we'll list it before that. Okay, then you'll have to file a written objection by that, or will you hear the matter then?
If it may be.
Because
next on
if
Monday,
it's
my lord.
after that and then you are allowed to take part, then the whole thing
Yes, the whole purpose will
doesn't
be defeated.
this thing make any sense then. Either you take part or you don't take part, that has to be looked into, isn't it?
My lord.
Has prayed for the learned counsel for the applicant has expressed urgency in the matter since the Mizoram Football Premier League.
Premier League, Mizoram Premier League, MPL.
Okay, the Mizoram Premier League.
Yes,
Is it?
season 12.
Season 12 is to commence
on
from,
21 August 2025.
okay, 21 August 2025. In view of the above submission, list the matter on, we'll make it on Monday.
My lord.
Okay, on Monday for the learned counsel for the private respondents to file their written objection positively by the next court date. Accordingly, list on 21, so and so.
List on 18, my lord. 21 is the commencement.
Okay, accordingly, list on 18, 8, 20, 25.
Much.
Yes.
Item 10.
Yes, what is I? Condonation application.
Yes, Your Lordship. Application for condonation of 304 days in filing the connected appeal. Your Lordship, notice has been served to the respondent number 3 on 13/11/2024.
So it's complete? Not yet.
Complete.
It's complete, my lord. I have submitted my written objections.
He has also filed. So what?
Ceased not represented till date.
Pardon?
Respondent number 3 is not represented.
Here, Ms. Tila Zakima is saying he's representing respondent number 3?
Number one, ma'am.
1. So
Represented
what
number
about 3? We'll have to wait for a return of service of notice upon respondent number 3.
An
Who is 3?
affidavit has also been filed in this connection. My prayer is that this application may be a hard ex parte against the
Who is respondent number 3?
number Banal Sheti.
Respondent number 1 is there. Respondent number 3, Dusty service complete.
Yes, my lord.
My lord, the respondent number 3 is the registered owner of a landed property covered by LSC number 514. That is the subject matter of
The main subject matter.
Yes.
Then we'll just then give her a chance. When was it received? Notice?
On 13/11/2024. There was a review application in the trial court, which was unfortunately dismissed by the trial court. In that case also, she does not appear.
Okay, then maybe she's not interested. At least let's note that deemed complete. Let's see. She's the main person who should be present, isn't it? So in the trial court, when the matter was considered in the trial court, was she represented?
In the original case, she was represented maybe. But she failed to file her WS.
Okay. Anyways, we'll give her final chance to appear. If she doesn't appear, we will, the IA can be heard in her absence, isn't it? Mr.
That'll be a trauma.
Nalbiak Tuama, learned counsel for the applicant is present along with Mr. T. Lalzikima, learned counsel for
Respondent number 1.
respondent number 1 and Mr.
PC Tangmoya.
P.C. Daltanmoya,
Tangmoya.
Tangmoya,
For the
learned counsel
respondent number
for respondent number 2. It is seen that none appeared for respondent number 3, though notice was duly served to her through dusty mode and affidavit to that effect was also filed, wherein it is noted in the affidavit that notice was received by the respondent number 3 on 06/11/2024. In view of the above, notice is deemed to be served upon respondent number 3. However, none appeared for respondent number 3. It is submitted by the learned counsels for the respondents that the respondent number 3 appear to be the main person whose rights are affected in the writ appeal, is it? Since, pardon? No, in the RFA, regular first appeal, since the disputed LSC is against her name. Full stop. In view of the above, this court find it fit to give final chance to respondent number 3 to be represented, failing which this court will have to proceed with the instant IA in her absence. Okay. List after 2 weeks. So since the main property is her name, what about the the parties respondent number 1 and 2? Have they informed her about the case?
Not to our knowledge.
You should make her aware, maybe she's not aware
Because,
that
my
she
lord-
has to have a counsel to represent her.
The main case in the trial court is that I have the innocent respondent number 1 had lended a certain amount of money to the respondent number 2, and for which collateral of an LSC bearing another LSC that does not belong to the
So,
respondent
so
number
if
3.
the matter is decided against her favor, she's the one who's
Your
going to
Lordship, there
lose.
was some compromise in the original
Yes,
case.
exactly.
A compromise was made between the respondent number 1 and 2.
So one
the
and
absence
two
of
and
respondent.
take the trouble just to inform 3 that your interest is going to be greatly affected. Maybe she is very simple, a simple person, and she doesn't know that ultimately she's the one who's going to lose out if she is not represented.
Yes.
You can decide between yourselves. The appellant and respondents number 1 and 2 can happily decide the matter, but the main person affected, respondent number 3, you should. 1 and 2 should at least say, please appear, otherwise you're the one who's going to lose out, isn't it?
Item 11.
May I please, my lord, as per the office note dated 11/8/2025, the adequate or unserved notice upon the sole respondent has not returned till date. So if service report may be awaited.
Okay. Lal Ropari, is it? Learned counsel for the appellant is present. It is seen that return of AD from the respondents is still awaited. In view of the above, list after 3 weeks.
Yes, my lord. Obliged.
Item 12.
May it please your lordship. This is an application under section 5 of the Limitation Act for condoning the delay of 149 days.
Okay, will you show notice?
Yes, my lord.
My lord, I have instruction to appear on behalf of the respondent number 1, who is the claimant.
The claimant.
Yes. I'll file my appeal within 3 days.
Okay, so you are the claimant. Now, what is the appeal about?
The,
Order and this thing, are they necessary?
yes, my lord, because we are challenging the liability.
Okay, of the respondent.
Yes.
Okay, yes. Mr. Zoram Chana, learned counsel for the applicant is present. The learned counsel submits that the application filed under section 5 of the Limitation Act, 1963 is for the condonation of the delay of 149 days in filing the connected MAC appeal against the impugned judgment and order dated 05/12/2024 passed by the presiding officer, MACT, ISOL N MACT number 24/2019. Issue notice to the opposite parties. Mr. Silal Fakzwala, learned counsel, accepts notice on behalf of respondent number 1/claimant. Notice be issued to respondents number 2 and 3 through registered mode within 3 days, returnable by 3 weeks. List after 3
My lord,
weeks.
if I may be allowed to take notice by way of justice to the respondent number 4.
No,
Because the address is not very clear as given in the judgment order. It's only stated that SBI General Insurance Company Limited. So it's
okay,
very vast.
so 2 and 3, okay, through this thing.
Yes, 4 by way of justice.
The learned counsel for the applicant submits that he may be allowed to take, he may be allowed to serve notice to respondent number 4 through dusty mode, since the address of the respondent number 4 is not clear in the
Judgment and order.
judgment and order, the impugned judgment and order passed by the presiding officer, MACT. Full stop. Accordingly, the learned counsel for the applicant is allowed to take steps for service of notice to respondent number 4 through dusty mode. An affidavit to that effect is to be duly filed thereafter. List the matter after 3 weeks. Meanwhile, requisite copies of the IA to be duly furnished to the learned counsel for respondent number 1. Yes.
Obliged, my lord.
Hearing item 1.
Yes,
May
what is
it
the
please your
matter
lordship.
about?
I have prepared a chart for you there, taping hearing.
This is an RFA.
Yes, my lord.
What is the chart? Let's see the chart, then maybe we can recollect what is this matter about.
That chart was prepared for the ground of appeal, my lord. In short, then in the column, there is a page number also. Then I already submitted the point number
What
one.
are your points?
Point I already submitted in the last occasion, point number 1.
What is point number 1?
In point number 1, the
Okay, it's concerning the recast plaint or what?
Yes, my lord, recast plaint. Without filing any miscellaneous application, they submitted recast plaint. In the meantime, 4 witnesses of the plaintiff rely upon the old plaint and already submitted in chief and cross-examination, and the state government also submitted a written statement, and based on written statement.
I'm recollecting.
Yes.
The matter was sent back to the trial court, isn't
Yes,
it?
my lord, for
But
treatment of Union of India.
then in the meantime, a lot of changes were there, something like that. Okay, so let's just go through this thing. So number A, what is A? Recast plaint. Then B?
Number B, the one of the plaintiff, Nema Silo, is left out in the new recast plaint. Then C, see here, Saitangpui Silo already submitted her examination in chief based on the old plaint. Later on, recast plaint, and submitted again examination in chief based on the new recast plaint. However, the learned trial court never stated which one will be relied upon by the court. Then D, the plaintiff have 4 witnesses. Then all the witnesses adduced evidence and submitted their examination in chief based on the old plaint. Then
Not the recast plaint, is it?
based on the recast plaint, Saitangpui only adduced evidence.
Did you mention that?
Yes, everything is there.
Where everything? Where's Saitangpui? I don't see the name.
Saitangpui is the plaintiff in the civil suit.
So where have you mentioned in your point?
My lord,
okay. However, except Saitangpui.
yes. Then E.
So it should be based on what? The recast plaint or
My
the
lord,
previous
as
one,
per-
according to you?
I already submitted the court order dated 16/9/2021 in RFA 16 of 2020. That is 8 page 279 to 281.
Wait,
Uh,
wait,
the
wait,
High Court-
279, have you mentioned here? Where, in your chart?
First one, my lord, the first page.
So,
My lord, for refreshing your memory, I may be permitted to. Wait, wait, wait. High Court also. I may be permitted to read over the order dated 16/9/2021, passed in RFA. My lord, page number 279 of Memorandum of Appeal.
paper book, which one? Book number?
Book,
One.
small one.
Now, is there any urgency in the matter?
My lord, in this order, my lord, direction has been given to the learned trial court.
Is there any urgency in the matter in you filing the appeal?
My lord,
If there's no urgency, because next week I'll be out for 3 weeks.
okay.
New cases, completely different. I don't think then again I won't be able to recollect anything.
Okay.
So hearing the matter now, when I will not be able to pass the judgment except after 3 weeks.
Okay. I may be preparing again the chart also for introduction, my lord. There should be some introduction.
I'm
because-
thinking I should release it
Yes,
from being
yes,
part heard.
yes,
If it's going to, we're going to start all over again
Yes.
and see whichever is the appropriate bench. Any bench, it's okay, but we'll release it from being part heard. And if it happens to come before this bench also, it's okay, because then we have to again revise, go through the whole thing and refresh our memories. So it's like going, hearing it again afresh anyways, isn't it?
Yes, my lord.
And an attempt should be made to have a day-to-day hearing in these long
Yes,
types of
my lord.
hearings,
Yes,
okay? So you give me a date, I'll release it from being part heard. And if it happens that this same bench hears it also, we'll make it a day-to-day hearing if we cannot finish in one day.
Yes,
Keeping it after a long time, again, we have to refresh our memory, and then we're just wasting the court's time. Okay. If it happens in this court, it's well and good. In the other court also, if it cannot be completed in one day, make sure that it is continued for the next day. Then the matter can be heard. Yes. Ms. Zarim Sangpui, learned CGC for the appellant is present along with Mr. C. Lalramzao, learned senior counsel for respondents number
1.
1, comma, Mr. L.H. Lianshima, learned senior counsel for respondents number 2, comma, anyone else? And okay, and Ms. Caroline K. Lungapui, learned counsel for the state respondents number 3 to 4. On hearing the learned counsels, this court find it fit to release this matter from being part heard and matter be listed again after, when do you want it? After 2 weeks. Okay. See.
Right.
Even if we complete the hearing today, I'll be out for 3 weeks. Then again, we'll have to refresh our memory, I might not do justice to the case. Yes. Anything else?
He told no, no.